My name is Michael Young, and I'm a lawyer who handles will contests. A common issue that arises in a will contest is whether the lawyer who prepared the will can also be the lawyer who defends the will in a will contest. So a very common scenario is a lawyer, say his name is Bob, drafts the will. Then the testator dies about 5 years later, and the beneficiary or primary beneficiaries of the will go back to Bob to offer the will for probate. The lawyer represents the applicant, the wannabe executor or administrator, files the will for probate. Common scenario, but then somebody files a will contest. Can that lawyer defend the will contest? Well, often they will try, but it's first of all not a good idea, and second of all, they will also often be disqualified. And the reason is that one of the most important witnesses in a will contest is going to be the lawyer who drafted the will, and that same lawyer often will oversee the will signing ceremony. So they are going to have material, important information regarding their memory of the testator, what the testator told them that they wanted, interactions with their office staff, and any discussions that the lawyer may have had with any potential beneficiaries of the will. All going to be very important testimony in a will contest. And Texas common law provides that a lawyer cannot serve as a lawyer in a trial and then get up on the witness stand and testify as to important information in the case. Generally, if a lawyer testifies, it will be regarding possibly attorney's fees or to prove those up. But a lawyer is generally not allowed, and it's also not a good idea for a lawyer who's personally involved in the case and will testify regarding the facts of the case. It's not a good idea. It confuses the jury, first of all, when a lawyer gets up and argues a case and then gets up on the witness stand and testifies in support of that case. And also, frankly, most jurors are just not going to find the lawyer credible. So even if the opposing party in the will contest does not file a motion to disqualify that lawyer, it may be malpractice for the estate planning lawyer to get up there and testify in support of it, because the jury is likely going to see that lawyer as an advocate and is going to discredit that testimony. So in short, it's a bad idea for a lawyer who prepared the will to be the lawyer in the will contest. And second of all, if the opposing side files a motion to disqualify, the lawyer is going to be disqualified anyway. So if you're involved in a will contest and you've hired a lawyer to probate the will who is also the drafting lawyer, and then the will gets contested, it's generally going to be very important for you to find a litigation lawyer who is experienced in handling will contests. And that's not necessarily going to be a lawyer who generally focuses on drafting wills and trusts and probating wills and estate administration. Those are completely different skill sets from a litigation lawyer who handles will contests.